Hi, everybody. I'm Erika Sanzi, the Director of Outreach here at Defending Education. And we are going to have a discussion today about a really important Supreme Court case that actually was heard yesterday. Oral arguments were yesterday, and it has huge implications for parents, not only in Maryland, which the case deals with parents in Maryland, but also nationally. And we're going to do our very best to leave the legalese and legal jargon out of the conversation as much as possible and explain this to you in a way that is easy to understand and makes sense to you as you sort of grapple with whatever may or may not be going on in your district. So lucky for us, Sarah Parshall Perry is here with us. And in addition to being our new vice president, she is also a lawyer who specializes in the very topics that we are going to be discussing and in the very topics that Defending Education deals with all the time. So Sarah, hi, and thank you for joining me.
I am so glad to be with you, Eric. It was a huge day yesterday.
Okay, so we're going to jump right in. Sarah listened to the full oral arguments yesterday in the courthouse. But before we talk about what you heard yesterday, can you do me a favor and just kind of set the stage? Here's what I can offer. It's not much, but it's a little. I can offer that this case is called Mahmoud versus Taylor. And I can also share that this involves parents from Montgomery County, Maryland. But after that, I'm going to have you take over and sort of explain what is this case and why should we care about it?
Okay, so the issue here is whether or not a group of religious parents can opt their children out of sexuality and gender identity curriculum that was offered to children as young as 3, 4, and 5. Now, this is not typical family life curriculum, what you would think of as sex ed, right? So Montgomery County Public Schools allows an opt-out for sex ed. It does not allow an opt-out for information directly related to LGBTQ themes, ideas, and issues. Now, some of the material that was presented to these young kids, and again, we're talking pre-kindergarten and kindergarten, were materials that were related to drag queens and non-binary identities. They were using a book called Pride Puppy, in which individuals were asked to look for items of leather, bondage, and S&M in an actual picture puzzle. This was pretty significant issue instruction. And they weren't just on the shelves. This was a big issue because some of the justices asked whether or not these parents' children were just exposed to the material or whether or not it was included in curriculum. And the answer was yes, it is included in the curriculum. And in fact, they are required by school policies to go through these books at least 5 times during the academic year. Now, think about how young and how malleable 3, 4, and 5-year-olds are. For all intents and purposes, they're guppies, right? So they're actually sort of forming the way that they think about the world. They are next to their parents, identifying and recognizing the second authority figure in their lives, which is very often their teachers in school. So this is a significant impact that materials like this have on an individual child and their parent, who has a constitutional right to direct the religious upbringing of their minor children. And so what these parents did after the opportunity to opt out was eliminated without explanation from Montgomery County Public School System, they said that they were going to seek in court this religious liberty opt-out expression. They went all the way to court. They have been fighting this for more than 2 years, and it finally made it to the Supreme Court. This is one of the first parents' rights cases we have seen at the High Court in a quarter century, which makes it a very big deal.
And also, just for viewers, it's interesting and important to note that parents from all religious backgrounds came together, before it was at the Supreme Court when they were just fighting at the district level. So there were Orthodox Jews, Catholics, Muslims, Ethiopian Christians, etc., who, again, all, despite coming from different faiths, had objections to this material in their children's school. And because they were, again, sort of blindsided and told that the opt-out was going away and that they would have to, children would have to stay in the classroom for these required materials. They came together, and now this case is at the Supreme Court. Okay, so I guess I wanted to ask you a little bit about when we hear about a case. Well, first, a couple things. Number one, um, I am a former teacher, and I also obviously had kids who went through. I had 3 kids who went through pre-K and kindergarten, and the materials that they're discussing are in this case that are in not only in the classroom and on the shelf, which we could argue is kind of strange, but are also being taught to the whole class, discussed, etc. I never saw anything like this in schools when I was teaching, um, or when my own kids were in school. So again, these are extremely ideological in nature. They're very colorful. They have friendly titles. They look like children's books, but they really deal with adult themes, and it's not surprising. I mean, it surprises me and shocks me in ways that the books are in this school to begin with. And I know everyone loves to say it's pre-K, kindergarten, and first grade because that's the most jarring. But truth be told, I mean, I just consider, like, in elementary school, I don't understand really what these are doing in elementary school more generally. But again, that's just my personal opinion. But help us understand how a case in Montgomery County, Maryland, at the Supreme Court matters for the rest of us.
Yeah, the issue of curricular opt-out is, let me say, as an initial matter, generally handled by state and local policies. So it's not unsurprising that Montgomery County decided that they were going to allow opt-outs, for example, for human sexuality and family life. And they were also going to allow them, for example, dissection in scientific advanced classes. There are opt-outs for field trips, for example. But they took away the opt-outs for this LGBTQA plus themed curriculum. This matters because it was prima facie evidence of religious hostility. Why? Because one of the things that happened at a school board, and here's why the factual record here is really important, they compared Muslim parents to xenophobes and white supremacists. And they eliminated, they said, the opt-out right because there were so many parents opting their children out of this LGBTQA themed curriculum. Well, no wonder, because I think a lot of us would argue that it is sort of inappropriate for children that young to be sort of exposed to these particular ideas. And it eliminates a parent's right to be able to say, listen, it's my choice to determine when and if I expose these children to this material. So it matters really to every parent, because when we're dealing with matters of curriculum, the first calculus is, okay, generally, states and local policies establish curricular opt-out rights. That's not strange. But here's what happens when it conflicts with sincerely held beliefs of parents and it interferes with their desire to raise their children as they see fit, and especially so on highly controversial topics. That's when the Supreme Court starts to take a closer look at what is transpiring in public education. Now, generally, we know that a parent's interest is constitutionally limited when it comes to things like curriculum, when it comes to things like school administration, when it comes to things like dress code or the hours of the day that school is held, or particularly what's included in course materials. But because this case specifically included the parents' religious beliefs, that got the Supreme Court's attention, because it wasn't just a parental rights claim. It was a parental rights claim that was complicated. It was enhanced by a religious liberty claim. And that was why the Supreme Court took particular notice of this case. But it matters to all parents across the country, because we're not seeing less of material like this. We're seeing more. Yep. And parents who are religious and parents who are non-religious have objections to the exposure of this material to minor children. And it's going to require courts to take a closer look at whether or not they have a legal opportunity to opt out.
Okay, and so depending upon how the court rules, that ruling would then impact parents and schools in all states, correct?
That's it. That's exactly it. Now, the relief requested here is something called a preliminary injunction. In other words, it means that you suspend the policy while the underlying litigation is going forward. So this actually, for purposes of this case, this isn't the end game. But what it will do is yield an opinion, and I think the right one. I think what I heard yesterday was that the justices are really keen to uphold the parents' rights. It is going to impact policies like this all across the country. And when you have religious parents who seek to opt their children out of this material, whether that's California, whether that's Mississippi, whether it's Rhode Island or Texas, those school districts are now going to have to yield a result that comports with the Supreme Court decision that is very new and applicable to these precise questions. So schools across the country are going to have to be paying very close attention to what happens.
One thing you all might have noticed, because Sarah has now said it twice, is she used the words family life. And again, as usual, it is wrapped in this very sort of vanilla, benign sounding terminology, because for some reason they've decided they can't say sex ed. I don't know why they don't just say what it is. First it was sex ed, then it was health, and now there's this new family life title in some places. So when you hear Sarah or anyone talk about family life curriculum and saying, oh, that's the only category that people could opt out of, it's because it's really the way that they're bucketing sex education, but they're deciding to call it that, which again, I find it all sort of weirdly manipulative and a weird use of language, but okay. So then my question is, you had said that in Montgomery County, and I think this is the case in most places, parents can opt out of this, let's just say, sort of sex ed health curriculum, but that's sort of the only bucket that they can opt out of.
That's
And
it.
so in Montgomery County, the issue was, and I was listening to the arguments as well yesterday, they're claiming, oh, no, we use these books for English or the English language arts, which again, okay, I mean, we're talking about kindergarten first and pre-K, kindergarten, first grade here, but whatever. And the idea is, well, you can't opt out of English class,
Right.
so you have to read these books or have these books read to you and do these class discussions, and then have the teacher essentially make sure that everybody in the room knows that, that there's one way to think about these issues, and all the good people think this, and everyone who doesn't think this way is a bad person.
Yeah.
And children who adore their teachers and want to please their teachers, which again is most kids at that age, obviously are going to be very influenced by that. So
Yeah. And in
what
fact,
does this mean? What does this mean for, explain sort of how this falls into the whole, well, it's not sex ed, it's not health, it's outside that, but yet parents still have rights.
Yeah, in fact, it was interesting because a number of the justices yesterday brought up the fact that this is not just exposure, it's designed to actually change opinions. In fact, Eric Baxter, who's counsel for the Becket Fund for Religious Liberty, who was representing the parents, actually said this material is designed, and this is the factual record. He was reading from the transcript in the trial below. It is actually designed to disrupt what he called cisnormativity, heteronormativity, and to disrupt what he called either or thinking, right? As, for example, sex as binary. They are trying to get the perspective of these kids to change. It is in its very core coercive curriculum, right? And by including it in areas like English language arts, in general studies, eliminating it from family life, there's no parental right of opt out, right? Because you can't opt out of what's considered core curriculum. And so for these preschoolers, for the kindergartners, for the first graders, it's sort of infused in the general ed portions of the actual education for them. And their parents have no right to either know it's coming or to opt them out when they know or learn that it is. And that's a pretty significant interference with parental rights.
And again, in case people are wondering what some of the words mean that she just said, because when I hang around regular people, which is what I do, and ask them, none of them know what these words mean because these words are like weird. So, cisgender, CIS, is the word that activists use to describe people who do identify with the gender that aligns with their anatomy. Oh, gee, what a concept. So cis heteronormativity, cis normativity, they're trying to say we have a problem in our country because we assume it's normal to identify as the same gender that aligns with your anatomy. Okay.
Bingo.
But we know that that actually is normal, and
Yep.
that there are cases in which that's not the case, but generally speaking, that is normal. But they don't want it to be normal, so they have to disrupt it. Then they talk about heteronormativity. And again, this is the idea that heterosexuality or male female couples are the norm, and we need to disrupt that. But again,
Right.
the reality is most couples, most marriages are between a man and a woman. That
Right.
doesn't mean that none aren't. So again, what they're trying with, it bothers them that that's the norm, so they feel like they need to disrupt it. And again, those are disrupting cis normativity and heteronormativity. Could I see that conversation in like a high level high school class or in a college class? Totally. I mean, again, I'll still say, because for fun, I ask people out in the world if they know what these words mean, and they don't, but even grown-ups. But the idea that you would be using young children as a vessel to disrupt cis normativity and heteronormativity, like that to me is like insane. Like that to me is lunacy. And it also, again, to your point, it's saying it's not just exposure, which again, I'm
Right.
not really sure why we're exposing young kids to the material anyway. Most children's books are about animals. But if you wanted to use students for that mission, it seems to me that they would need to be a lot older, and then
Yeah.
we could criticize that level of indoctrination. But here we're talking about very young children. So again, like
Yeah.
I feel like this is kind of sickening. Um, and again, I say that as somebody, I don't have a problem with, you know, marriages that are different. I don't have a problem with the person who says, I don't feel like the sex I was born, whatever. I have a problem with this being not just even presented to children, which is a problem, but also, again, this idea of coercion. And I heard them saying that when you're dealing with small children, especially, it is coercion, because if you say to not believe this is hurtful, which we know they said it's in the teaching materials,
Yeah.
um, then it's like, to the child, it's like good person, bad person. I want to be a good person. I want my teacher to think I'm a good person. So I'm going to hop on board the crazy train of this gender ideology because I don't want my teacher to be mad at me.
Yeah. And I want to add a little bit of a distinction here. Some of the press on the case talked about the fact that parents were challenging the curriculum, right? And in fact, NPR yesterday had a headline, big headline, that said, "Who gets to decide curriculum?" Right? The Supreme Court or the school boards. That is a total mischaracterization of the case, because the parents are not challenging the curriculum. Multiple times they were asked by Brett Kavanaugh, by Amy Coney Barrett, by Samuel Alito, "Are you challenging the curriculum?" The answer is no. They simply want the right of opt out, right? They understand it's well within the purview of the school board to develop what they like, the school to develop what they like. State curricular standards are what they are. The parents are not challenging the curriculum. They're simply saying, give us the opportunity to opt our minor children out because they're so young, they're in their formative years. It conflicts with our sincerely held religious beliefs, and we should be able to know and opt out of this material because it conflicts with our ability to raise our children as we see fit.
NPR also decided to leave the name of the case out of its articles because the name of the case, Mahmoud versus Taylor, it's a very Muslim sounding name, and NPR, of course, loves to, pretend that it's like pro-Muslim or pro-minority or anybody that's not a Christian, like we're on their side. But if they share the name of the case, then it's like the narrative falls apart. So they've just been leaving it out of their write-up, which is kind of odd considering you wouldn't put that it's a Supreme Court case. Usually you include the name. Okay. So, and that's actually a really important point because I'm ranting about the curriculum. And of course, I don't like that those are the choices. But your point is important, that the case is putting aside whether or not they agree with the curricular choices. It is just give us the right to have our children removed from the room when you are, reading picture books about pride parades and doing, can you find the leather?
Yeah.
On the drag queen in this picture book about pride parades. Or if they just want their children, again, to not be exposed. Okay, so can you give us a sense of how you think it went yesterday? In terms of you're listening to the oral arguments, if there's any key moments that you want to share, or also if you got a sense of how you think the court may rule. Of course, there's no way to be positive, but like just a sense based on your years of experience and sort of what you heard from the justices.
Yeah, reading the tea leaves on this one indicates to me that the parents are going to win. And that would be incredibly gratifying, I think, for parents who are finding themselves at the sort of sharp end of the spear in public education. It's interesting because Justice Jackson said, they can just take their kids out of public education. They can send them to private education. They can homeschool them. And Eric Baxter, who's the attorney for the parents, answered by saying, that's not practical. It wasn't for me as a single mother of 3 kids, 2 of whom needed special education services. It's not for a lot of parents. Parents do not relinquish the right to direct their child's education when they get to the schoolhouse door, regardless of whether or not it's public education. And what the dissent said in the lower court, in the Fourth Circuit, and that was the court that heard this case before it made it to the Supreme Court, Judge Quattlebaum, who wrote that dissent, said, you've put them to an impossible decision. They either get the public benefit of public education or they get to keep their religion. And you're telling them they have to choose. Well, that's not the way the Constitution works. And it's not what 102 years of Supreme Court jurisprudence has actually said. I love the fact that Justice Gorsuch said, I have read Pride Puppy. You're talking about telling these minor children, essentially, for all intents and purposes, babies, that they have to look for drag queens and leather at pride parades. And then he pointed out the fact that in the school board meeting, these Muslim parents were called xenophobes and white supremacists. That's not only evidence of religious hostility, it makes the court look even closer at why there was an opt-out right and why that opt-out right was eliminated, because the school allows opt-out rights for everything from certain scientific experiments to field trips and to certain things in between, but does not allow for opt-outs for this material, I think really did not sit well with the justices. And I think what I heard was at least 5 and possibly 6 of them who are really keen to say, listen, the burden on the school is so minor. It is what the court would call de minimis, right? Very, very minor in the grand scheme of things. The attorney for the county school board said, oh, listen, it was infeasible. We had too many people who were opting out. Well, the fact of the matter is, once you eliminate that opt-out right, and you get so many parents complaining about it who recognize that this is an issue with impact for how individual children are raised, that this is going to be something that school districts across the country are going to have to wrestle with. And the argument that it's infeasible to manage the number of opt-outs did not weigh as strongly as the right of parents to direct their children's religious education. I think I heard a good outcome here. The three sort of typically liberal voting justices, Sotomayor, Kagan, and Jackson, had some very difficult, pointed, aggressive questions. At one point, Justice Sotomayor cut off Justice Alito, which responded, and he responded by saying, "Can I finish my question?" At points, it got very, very heated. It was 2.5 hours of oral argument, one of the longest oral argument segments that we've heard in any case this term. So it was a significant day, but I think I heard some pretty good things in the lines of questioning, and a failure of the Montgomery County School Board to offer a good analysis for why they couldn't just allow an opt-out right.
Okay. Actually, and one thing, I will make sure that is there a way to, if people want to hear the oral arguments and they missed it, I assume there's a way to go back and listen. So we will somehow get that out, whether it's in our newsletter or we'll put it out on our social media, because I think some people would probably be interested in going back and listening. I always find it kind of fascinating. It means a little bit nerdy of me, maybe, but if people want to listen, we'll get that to you. I have a couple points to make, and then I'm going to ask you a final question. One is, when they were up there talking about, well, if you don't like it, just go to another school. I literally was like, are you people who've been kind of against school choice forever suddenly becoming the poster children for school choice right now? Because it was essentially like, oh, you don't like this public good, keep paying for it with your taxes, but
And then
take
go
your
elsewhere.
kids somewhere else. And oh, by the way, what was even funnier is it's like, well, yeah, you are all lawyers and you probably all make enough money where private school might be an option for you.
Yeah.
But the average family income in the United States is $79,000. So where exactly would they like all of these parents to send their kids just
Bingo.
because they don't want them having to read Pride Puppy
Right.
in a kindergarten classroom? So that was my first. I just thought it was kind of funny because it's that usual, like, oh, I guess you're making the argument for school choice. Thank you, Justice Jackson. The other thing I wanted to mention for everybody is that even Randy Weingarten, now again, president of the American Federation for Teachers, probably arguably one of the biggest villains when it came to COVID, because she worked tirelessly to ensure schools stayed closed as long as possible. Even she came out in a national television interview last night and said she would not have children read these books in these grades. And she's pretty extreme and a major ideologue. So for even her to say she thought these were kind of like iffy means that they're like totally inappropriate.
Yeah.
Okay. Actually, I have two more questions. One is, what I know that the argument is about religious belief, right? We need to be able to opt our children out because of our sincerely held religious beliefs. But I have fielded quite a few questions in the past few days from people saying, well, I'm not a religious person, and I think that these materials are totally inappropriate. Would I be able to opt out? Or they say, I am a religious person, but that's not what's driving my opposition to these materials. My opposition is based in the fact that they're not age appropriate. So what happens to those parents? Let's say that they win, that the parents win at the Supreme Court. What happens for parents for whom the objection is not based in their religion?
Yeah, so that's going to depend a lot on how the Supreme Court writes its opinion.
Okay.
Because there are two associated claims here, right? So one is rooted in the First Amendment free exercise clause, which we all know, from basic civics class. And the other is the 14th Amendment due process right to sort of guide your child's upbringing, right? That was first recognized in the case I referenced earlier, Meyer versus Nebraska, all the way back in 1923. So how the justices take those two issues and work them together, do they lead with the First Amendment? That makes it harder to opt out if you're not a religious parent? Or do they lead with the 14th Amendment with kind of an ancillary reference to the First Amendment? That makes it a lot easier. So it's going to depend very significantly on how the justices kind of work through this knot, and how they actually come to their conclusion in the end. So I would give a qualified yes for parents of both types who want to opt their children out. It's certainly going to make it harder for a school to push back and say, you have no opt out rights, because they will be able to point to a very recent Supreme Court decision that says something very, very contrary. And I think for parents, and particularly in Montgomery County, there's a recognition that these guys are really bad actors. In fact, this was the second of two cases that went to the Supreme Court this term. The first was what's called a facial challenge. In other words, you're challenging a school policy that could never conceivably be constitutional on its face. In one of these, as we know so well, because Defending Education has been keeping a record of these, school gender secrecy policies. Now, for whatever reason, the court didn't take up that lawsuit against Montgomery County Public Schools, but it did go to the Supreme Court in this term. So it indicates kind of that these guys are regular bad actors. But I would offer a qualified yes for parents of all kinds who really want to know how they can opt their kids out of this material in the future, because it largely depends on how the Supreme Court writes its opinion and how it gets to yes for these parents.
Okay. And my final question is, when will people know the verdict? When will people, well, that's not the right word. When will people know how the Supreme Court has ruled on this case?
So they generally leave what are considered their most controversial cases toward the end of the term. This is going to be something I anticipate we won't see anything on until very likely the middle to possibly the end of June. Now, the term this season will end either the end of June or first couple of days into July. And that is when all of the opinions are all issued. But remember, this is a really crowded docket this term. We saw everything from porn and the First Amendment to a ghost gun ban regulation to Medicaid funding for abortion. We've seen huge, high profile marquee cases. This is definitely one of them, but I don't anticipate we hear a peep from the court until probably at least the second week of June or thereafter.
Okay, that's very helpful because, again, that's another question that I was getting. What I noticed is some people kind of thought this was either going to be next week they would hear, or they thought it wouldn't be until the fall. Okay. I don't know if you want to make a prediction. I'm going to make a prediction. And I'm going to say that I think they're going to rule in favor of the parents, and it's going to be 6-3. What do you think of my prediction?
Yeah, I would agree with that. I would say the wild card right now.
Kagan, right?
Yes, I do think so. But, Barrett did not start out as favorably for the parents as I thought she might be. Remember, she's a mother herself. She's a religious parent. Her kids go to a parochial school. It took her a little bit of time to kind of build up some steam to ask questions that sounded like they were more supportive of the parents. So she too may be a wild card, but I think we have at least a 5-4, and I'm hopeful of a 6-3 in this decision for the parents.
Any chance of 9-0?
No way.
No, I'm only saying because I was watching Mark Halprin on his two-way platform the other day, and he was like, if that's not a 9-0 decision, I'd like somebody to explain why.
Well,
and
listen.
In my head, I'm thinking, I don't think you're going to get your wish, Mark.
No, you won't get Sotomayor, and you definitely won't get Jackson. And, Kagan could be sort of a 50-50 both ways. But I'm going to tell you what, this is, Justice Kavanaugh called it. He said, and he was looking at the attorney for the school district and said, you got a hard case to argue. And he does.
I mean, in some ways, that almost felt like a mentor talking to like someone saying, like, you were dealt like a really difficult hand.
Yeah.
And you really did your best with what you had.
Bingo. That's exactly it.
Which in
That's
some ways
exactly
I thought was it was kind of a nice thing to say before, voting against him.
right,
Um,
right.
okay. Is there anything I didn't ask that you want to be sure that we cover or that you get a chance to say?
I think this is not going to be the last time we see parental rights at the Supreme Court. Remember, we went for a quarter century. Last time the court weighed in was back in the year 2000 in a case called Troxel versus Granville. I was surprised that this was the case that the court took up. I'm thrilled that they did. But I'm going to tell you, we could see another one next term. Remember, we've seen that the gender secrecy policies already go up on a filing. And Justice Alito, in dissenting from that dismissive review, said, we're going to have to deal with this sooner or later. This is an issue of growing national importance. I would not be surprised if we see more cases on these gender secrecy policies in the coming term in October. So I don't think it's the last time
I
we're going to
agree.
see it. Parental rights are of increasing national significance. We know how important this is. Our organization strives to protect and ensure parents are protected within public education and the way they want to raise their kids. And we're not going to stop. I don't think the litigators are going to stop. And I'm hopeful that the Supreme Court continues to offer its protection to parents who need it.
Yeah, I totally agree because what we've seen is this massive swing. Even the swing in parents and how they voted in the most recent presidential election. We saw a very big swing of voters who were parents of kids under 18. And I think, again, like this has become very nonpartisan in ways because the average parent, regardless of political party, like generally has a sense of what is and is not appropriate in a school. And so many schools have just gone so far down, the path to Crazyville that I think that what we're seeing is kind of an uprising of parents. And again, people in the media do like to paint it as sort of a right wing thing, but the data doesn't bear that out. And also just in our day to day, I live in a completely blue state. We don't have a single person in office who's not a Democrat. And
Yeah.
yet the conversations about these issues, they're like 90-10 issues where parents are like, this is just totally not right. So,
Yep.
well, Sarah, I'm so grateful to you to have you with us. So this is like our first like one-on-one. I get to celebrate that you're on our team, take advantage of your incredible knowledge and wisdom, and help people understand these cases that are complicated, but also can seem simpler if we have someone like you to explain them. So thank you for helping me better understand. Thank you for helping our audience and our parents better understand. And with that, we are going to sign off. So again, I'm Erika Sanzi from Defending Education. I was just with Sarah Parshall Perry, also with Defending Education. We thank you so much for joining us. We hope that you found this helpful. We will make sure that we get a link out to you somehow um, with the oral arguments for people who actually want to listen to them because they were really interesting. And with that, I'm signing off until next time. So bye, everybody. Thanks again.